Good morning and thanks for tuning in. I'm Holly Shields here for Kalkine TV, welcoming you all to another edition of Executive Corner Expert Talks. Now, the Australian Open Tennis Championship wrapped up on Sunday, and once again the organisers put on a spectacular world-class event. However, this year's tournament has also seen its fair share of controversy. Of course, I'm referring to the men's world number one, Novak Djokovic's eventual deportation by the Federal Immigration Minister Alex Hawke, the supposed threat Djokovic's personal stance on COVID vaccination posed to the federal government. This is all in spite of Djokovic receiving a medical exemption from the vaccination from two independent boards before his arrival to Australia, as well as his initial visa cancellation being overturned by Judge Anthony Kelly in Federal Circuit Court after Djokovic had spent a number of days in a detention facility. Well, here to discuss the case today is accredited specialist immigration lawyer Christopher Levingston, who heads the firm Christopher Levingston Associates. Welcome to the show, Christopher. It's great to have you on.
Thank you very much for the invitation.
Pleasure to have you with us today. Now, first of all, the whole Djokovic saga lasted from the 6th of January when he was denied entry to the country until the 16th when he was finally deported. So why was his visa cancelled initially when he had already received that medical exemption?
Well, when you arrive at the border, you've got a visa, but a visa is not permission to enter Australia. It's simply an invitation to present yourself at the border and then seek admission. So when he arrived at Tullamarine very, very early in the morning, he ran into Border Force, who by reason of a shift change weren't inclined to give him every opportunity to present his case. And notwithstanding the fact that they then exercised powers to cancel his visa, subsequently upon review by His Honour Judge Kelly, that decision was set aside because of a breach of procedural fairness.
Right, but the whole process as well, did that need to be drawn out for as long as it was, do you think?
Well, if you're going to seek judicial review, you've got to get before a judge. And so Mr. Djokovic was constrained by the reality that he arrived early in the morning. He had to get, a decision was made, he was taken into immigration detention. That then got the ball rolling. So then an application is made to the courts. The courts have to constitute and then sit. That takes time.
Right, that does take time indeed, especially a figure like Djokovic. But do you think if it wasn't him, this tennis star in question, would the outcome have still been the same?
That's a great question. I suspect that what's happening at the border every day is that people are being refused entry for a variety of reasons. It is inevitable that there'll be people at the border yesterday and today who will be refused entry, and if they don't have their documentation in order, specifically they don't have the vaccination certificates or the clearances, they will be refused entry and will go into immigration detention. That may not be for 6 or so days. They may in fact be removed the same day, subject to a seat being available on another plane. So to the extent that Mr. Djokovic attracted the attention of Border Force and ultimately the Commonwealth, the problem seemed to be a lack of documentation. But the longer the matter went on, more problems emerged. And one of those was in relation to the travel declaration form made under the Biosecurity Act. And that itself was incorrect. And that could have also enlivened the cancellation powers. So it's a tricky business. People do get their visas cancelled every day, and I suspect that that will continue with this particular emphasis upon COVID.
Absolutely. But considering the final decision there, it was Immigration Minister Alex Hawke who admitted that Djokovic in fact wasn't necessarily at risk of spreading the virus, but rather his presence may be at risk of an adverse reaction by some members of the Australian community on the basis of their concerns about his unvaccinated status. Would you say this decision was fair from a legal standpoint?
Well, it was legal. The decision made by the minister was legally correct, but I think that Mr. Djokovic had a combination of problems. The first problem was this. Ordinarily, a person who's famous, has got a lot of money, a lot of resources at their disposal, they generally sort of sail through the system without too many problems. The problem in reality ultimately turned upon whether or not Mr. Djokovic was a symbol. And given that the government's got a very, very strong position in relation to COVID, and they've got a lack of tolerance for alternate or dissenting views, Mr. Djokovic was unlucky because he was held out by the minister rather than on any proper factual basis, in my opinion, as being some sort of poster boy for the anti-vaxxers. As to whether or not that was in fact the case is really irrelevant, because when the minister exercises the powers, all he has to do is exercise the power reasonably. And so ultimately the full federal court decision turned upon whether or not the powers had been exercised lawfully by the minister. They found that he had, so as a lawyer I can't complain about the way that the law operates. It just operates, and the courts ultimately have oversight and review. So I line up with the decision of the full federal court.
Right, it's very interesting there. So obviously there was an element of, this is a public figure, he has a substantial influence perhaps, so perhaps it was, as you say, legally within his right to make that call. Now, surrounding the case, we've often heard the mantra about the rules being the rules, but is there a moral element to this, do you think? Is there a moral implication of not perhaps wanting to put something in your body that you don't want to? Does that concern you at all from a legal basis?
Well, given that the powers will reside, the powers that the minister exercised reside in the Migration Act 1958. That's a piece of legislation created by Parliament. Ultimately, the courts will enforce those powers. I guess the situation is this: if you thought that the decision was so unfair, or that the minister's powers were so godlike that they offended ordinary sensibilities, you can ventilate about that in a public forum, but ultimately the only way to address it is to get elected to Parliament and change the law. So at the end of the day, the Migration Act 1958 isn't designed to be fair. It's about the accrual and dispensing of power by important, powerful people. The Commonwealth loves power, it exercises the power. So to the extent that the Prime Minister says the rules are the rules, he's right. But often there's a moral dimension. There's often questions about fairness, but at the end of the day, they all fall away because the legislation is king.
Right, and do you expect this to change anytime soon, perhaps, do you think?
That's a great question. I don't think that the minister's going to give up powers, and there's no indication historically that once powers are gained by government, that they ever give them up. So I think that these powers that reside in this current minister and will reside in future ministers, and these powers have been exercised by previous ministers, I don't think that anybody's going to say, look, it's a bridge too far. I think that once powers are taken, they're exercised, and very rarely are they ever given up.
That's an excellent point there, and I'm inclined to agree with you. But as far as that goes, it's been great to hear your insights today. Thanks very much for joining us on Executive Corner Expert Talks. It's been great to have you on, Christopher.
My pleasure. Thank you very much for inviting me. Thank you.
And thanks for your time as well, viewers. Stay tuned for more live updates. This is Holly Shields signing off.